Radha Krishna, and thanks to ISACA Hyderabad and all the members who are present here. FDPPI is very happy to interact with you. And in fact, this is the program which Radha Krishna has launched as the first program of the FDPPI chapter in Hyderabad. So I congratulate him for the initiatives which he has taken. It was indeed a long wait for most of us for this particular law. In fact, the first time the law was actually presented in the parliament perhaps was in 2006 when the Information Technology Act was also sought to be amended. So along with ITAA 2006, this Personal Data Protection Act of 2006 had been presented as a bill in the parliament. However, that did not get passed, and only after 2017, with the what we call as Puttaswamy judgment, the Supreme Court spoke about the privacy being a fundamental right in India, that more action started in this domain, and we now have this DPDPA 2023. FDPPI recently had the privilege of meeting Justice K.S. Puttaswamy, who was the person responsible for this act to come in India. That gentleman, of course, is today 98 years old. We actually awarded him a title from FDPPI's side as Privacy Pitamaha, and we are thankful that the government has ultimately come up with this law, which was something which professionals waited for a long time. There are different kinds of professionals who are looking at this act. One was, of course, the privacy activists who wanted privacy to be recognized as an important human right, and wanted appropriate, you can say, restrictions on the use of personal data, particularly by the business and the government. And the industry was, of course, looking at it as with some kind of a fear that if the law is very stringent, their business could be affected. And professionals were also looking at it because we know that in corporate environment, we all handle data, and we would like to know whether there is any reason to watch our backs with penalties which this law or this kind of law could apply. Since 2018, after GDPR became an effective law, we have all been worried about companies being penalized with large penalties. Fortunately, of course, India basically is a data processor in most of the GDPR instances, and we have not had any instances of GDPR fines. But globally, we know that the GDPR fines have gone to the astronomical levels of up to $1.2 billion US, and the industry was very fearful that India also we may come to a situation where penalties are running to crores of rupees based on a percentage of turnover could be imposed. In fact, GDPR has a maximum penalty of 4% on the turnover. And in fact, Singapore, of course, GDPR was 4% of the global turnover, and Singapore went to the extent of making the penalty up to 10% of the Singapore turnover. So definitely, this was something which was being watched out. And fortunately, I think the government decided that we have to take different stakeholders together, both the business, government, and the privacy activists, and came up with this law, DPDPA, which is as reasonably industry friendly as it could be. Privacy activists will continue to oppose, saying that no, this is a very diluted law. But ultimately, we have to see that industries need to exist. We cannot for the sake of the privacy right, kill an industry. So we have to ensure that there is a harmonization of the requirements between the industry and the privacy activists. And to some extent, that has been achieved in this particular act. We will, as we go ahead with this particular session, briefly talk about the contents of this act, and then we will go into a lot of discussions. As Radhakrishna was telling, that there have been a wide industry-wide discussions on this act since the last 1 month, which is actually something which people like us are very happy, because in 2000, when the Information Technology Act came, the industry had not actually recognized the emergence of the law at all for a long time. In fact, for several years, when ITA 2000 became a law, we used to see that even at the government level, the earlier draft law called E-Commerce Act 1998 was considered as the law of the land. In fact, if you go through naavi.org and open up the historical pages, which started right from 1998-99 onwards, you will see that at many places I would have perhaps pointed out how our US consulate had been talking about E-Commerce Act 1998 when it was not there at all. And the industry level, very little awareness had been there, and it took years after years to actually make companies realize that there is an act called Information Technology Act. Even today, people have recognized DPDPA, but they have forgotten that there is a law called Information Technology Act. And in fact, as we go forward, there is only one section of Information Technology Act which has been replaced with this DPDPA, which means that the rest of it, IT Act remains, and IT Act, that is Information Technology Act, applies to data in general, which includes personal data as well as non-personal data. And this DPDPA covers personal data. So together, they are important for the organizations, and several aspects of personal data protection also fall within the range of ITA 2000. In fact, if a data principal has to claim compensation for any data related loss, the law which he has to invoke is Information Technology Act and the adjudication under Section 43 of the Information Technology Act. That is the close interaction between ITA 2000 and DPDPA. If there is a dispute between data fiduciary and data processor, where a data breach has taken place with the data processor, then data fiduciary has to claim damages from data processor. Again, he has to invoke Information Technology Act for that purpose. So Information Technology Act and DPDPA will work together, and that is the reason why FDPPI in its training programs now, which we call as the module on Indian law, has integrated the Information Technology Act and DPDPA into one single training program. So similarly, when we speak of the audit under this particular act for data auditors and data protection officers, we have integrated the requirements of compliance of this act along with the requirements of protection of personal data under ITA 2000, as also the BIS standard for data governance. So we have an integrated model of data protection audit, which of course on some other day, some other occasion, perhaps we'll have time to discuss. So this is the background with which now we are looking at DPDPA as the future of data protection regulations in India. Just a bird's eye view of this particular act, we need to look at what is DPDPA and its applicability. Then we briefly can look at obligations and penalties and what kind of measures of compliance the industry has to look at. Rest of it, we will always take it up in questions and answers. So this DPDPA, which is Digital Personal Data Protection Act, by name itself brings the focus on the handling or governing the digital personal data. So we don't just fancy and say we are protecting the privacy, because the concept of privacy is very complex. And we say privacy is a state of mind of a person to feel left alone. Okay, a person feeling left alone, if I have to understand as an organization and then protect that privacy, it is practically not possible. And to have a law, to make a law which protects the feeling of being left alone and about 140 crores of people, again, it is an impossibility. So it is only theoretical that people have been talking of, can we pass a law for protecting privacy? So what the government has done is, while privacy protection is the fundamental objective of this law, what we are indicating in the statutory law is how digital personal data has to be governed. Now, which means that we are looking at personal data in digital form, which is either collected and processed by a computer, or we have collected it manually and then made it into a digital document. So this law applies to that kind of data. The question therefore arises, what about privacy in non-digital form? The government is not saying that there is no privacy if it is in paper form. What it only says is this act will look at digital personal data if there is an issue in terms of protection of privacy in non-digital format. The current clause has to take care of it. The Constitution has recognized that under Article 21, privacy is a right. So whether it is orally or through paper or through electronic means, the constitutional right remains. Now, whoever is responsible for the constitutional right has to take care of that responsibility. And in the early days, jurisprudence people, you were telling that a constitutional right is an obligation for the government and not necessarily an obligation for the private sector. But Kerala High Court in the Woman Chandy case made a different observation. It said that the constitutional obligations cannot be ignored even by the private sector. So it should be considered as an obligation by the private sector also. So therefore, I see that the portion of privacy which has been omitted by this law is adequately covered elsewhere. And the government feels that if you look at the risk profile, risk of privacy loss in digital world is far, far more than the risk of loss in the paper world or even oral world, and existing laws of IPC should be able to take care of that. So with this particular law focuses on digital personal data, which is a matter of prime, you can say, focus at this point of time. And it imposes certain obligations on the corporate entities, and penalties could be up to 250 crores or higher. There are no criminal punishments in this particular act. However, when you combine it with ITA 2000, criminal punishments could come forth, because whenever a data breach happens in personal data, it is also a breach in ITA 2000. And therefore, if there is a wrongful act under ITA 2000, which has caused the data breach recognized under DPDPA, punishments will come under Information Technology Act, because ITA 2000 has a section called Section 66, according to which any diminishing of the value of information residing inside the computer can be considered as an offense with 3 years imprisonment. Impersonation, identity theft, which are all privacy related issues, are covered under Information Technology Act. So this act doesn't have criminal punishments, but it is covered under Information Technology Act. As I told you, it replaces Section 43 capital A of ITA 2000. However, there are several other sections of ITA 2000 such as Section 72A, 67C, then 70B, 69 family, 79, 85, they all remain, and they address different aspects of privacy and consequences of privacy being breached. Therefore, we are saying that ITA 2000 and this is a twin set of laws which will be affecting our data protection requirements in the coming days. Now, if that is the law, and we are looking at a corporate entity, the very first corporate step I look at in terms of what this company suggests is for us to decide whether this law is applicable to us or not. So that is why I am suggesting that all companies need to take this very first corporate step, which is the board meeting together and passing a resolution, taking recognition of this act first. Okay, the members of the board have to recognize that there is a law like this, and we need to actually make a business impact assessment. And who will do that business impact assessment? Maybe they will call the CFO and say that what is the financial risk as a consequence of this act having been passed. I mean, trying to have a cyber insurance of 250 crores or anything more. So that is the first thing. Of course, CFO may not know much about the act itself. So he will immediately call the CISO or somebody and say that, please let me know what is this act. Okay, so that is how I think the first corporate step has to be rolled out. And I hope most of the companies by this time in the last 1 month must have had a board meeting, and they should have taken some action on this. With this background, if we try to explore the requirements of whether DPDPA will apply to us, the act appears to be applicable to all type of entities, unless it is exempted specifically by a notification, which means that whether it is a small scale industry or a large scale industry, whether it's an IT company, non-IT company, whether it's an educational institution, or whether it is a society like ISACA or FDPPI, as of now, there is no exemption and all of us are coming under the DPDPA. Maybe in future, government may think of creating a category of exempted data fiduciaries. We will have to wait and see. But if any person or any organization is processing personal data in India, then such an organization comes under this act. In case data is being processed outside India, if that data is related to any goods or services which are being provided to data principals in India, that is directly to the individuals, then even if the data is being processed outside India, that comes under this act. If any individual is processing any personal data, if it is for business purpose, that will also come under this particular act. But if he is processing it for personal domestic reasons, it may not come under this act. The thing which comes under this act is what we call as personal data. Personal data is data related to an individual, and if a set of data identifies an individual, we call that as a personal data. Data which is related to a company, even a HUF, even a proprietary firm, or even a LLP or something like that, is not personal data. That is business data. So we have to make a distinction of personal business data and personal data to understand the applicability of this particular law. Every organization has got employees, therefore employee data comes under this act, but there is a provision for legitimate use, and with that, employee data may be processed without much of a difficulty. Okay, and if an organization is handling any retail customers, then that will come under this act. So even manufacturing companies which are having, say, retail showrooms, or they are selling their products through e-commerce websites, they also come under DPDPA. Okay, so personal data processed by a business entity could be considered as business contact information. It should be exempt. More clarity on this, of course, may come sometime later. Otherwise, personal data is data about an individual, which is something which can identify an individual. See, in our, let us say, corporate environment, we sometimes have elements of personal data. We call that as data identifiers, and GDPR kind of law blindly considers everything as personal data. For example, a cookie on a website is considered personal data in GDPR. Now, I personally feel that only if the data is able to identify an individual, then it should be called as personal data. Otherwise, it is an identifier, but not personal data. Maybe it is necessary for the industry to recognize a category of data called personal identifiers not amounting to personal data. Like in the Income Tax Act, we have got a category of non-residents and residents but not residents kind of a thing. But this concept has not yet crystallized, and hopefully it will come in due course, because we are saying something which is not there in GDPR. The industry will frown if I say something against GDPR, because people think GDPR is the gold standard of privacy. But GDPR is to be commended for the what it did for privacy across the globe, but that doesn't mean that we cannot have a law which is better than GDPR. So the one thing which we want professionals to realize is to consider DPDPA as an independent sovereign law, and we have to look at it as something which can have its own interpretations, and it is not necessary that we toe the line of GDPR in all aspects. Okay. So in an organization, what happens? We have got these personal identifiers lying around in different places, and sometimes when like a jigsaw puzzle, two of these identifiers come together, they together become an identifiable personal data. So personal data gets generated in the ordinary course of business, and that is where the identity of personal data, discovery of personal data becomes a very difficult task. So when we want to apply this data, we need to actually create an inventory of personal data, and we have to have our own system of putting together identifiers and then creating a table of personal data set with appropriate identity and so on. So this is another important preparatory task which is necessary for taking on this particular act. Then the next question which an organization has to look at is, who am I as far as this DPDPA is concerned? Am I a data fiduciary? Am I called data processor? Am I the data principal if I am an individual? Am I a significant data fiduciary? Am I somebody called a consent manager? So these are all the different roles which this particular act has given, and depending upon the activity of an organization, it may have different roles, and sometimes the same organization may be a data fiduciary in one process, it may be a data processor in another process. Therefore, while trying to build an inventory of data, we need to actually first start with an inventory of processes, and within each process we have to identify, am I a data fiduciary, am I a joint data fiduciary, or am I a data processor? This becomes very important for us to determine what compliance is there. Government has said that they will separately come up with some kind of a guideline on identifying what is called significant data fiduciary. See, various other laws spoke about data being sensitive. So there was personal data and sensitive personal data. India also had sensitive personal data concept under section 43 capital A. And that's why the rule of reasonable security practice was called FDPPI rules. So today, most of the companies understand FDPPI rules, but now there is no FDPPI rules. Why? Because the categorization called significant, the data which is considered as either a special category of data or a sensitive personal data is no longer there. Instead, this particular act directly categorizes data fiduciaries into general data fiduciaries and significant data fiduciaries. And while defining a significant data fiduciary, it will follow multiple criteria like the volume of personal data processed, sensitivity of personal data processed. Therefore, the sensitive personal data comes here in the form of identifying a significant data fiduciary. So therefore, even if an organization is small, even if the number of employees is small, and the number of data sets which is processed is being small, if the data is very sensitive, then government can pinpoint that particular industry or a class of such industries and say this class of data fiduciaries will be called sensitive, significant data fiduciaries. So it will take into account the risk to the rights of the data principle, potential impact on the sovereignty and integrity of India, risk to electoral democracy, security of the state, and public order. On any of these criteria, the government may define either a single data fiduciary or a class of data fiduciaries as significant data fiduciaries. This way, the government retains the option to choose a particular class and then apply this category. And once a significant data fiduciary is defined, then there may be some special obligations related to them. We'll see what special obligations a little later on. And another important first step which an organization has to look at is what to do with legacy data. See, many laws just gave a new law without worrying about what happens to the legacy data. So here our act has clearly mentioned that if you already have personal data, then you must try to get a consent under the new act. This new consent may have something different from the previous thing. So even if you're processing personal data based on a consent so far, it is necessary for you to send out a communication to all the current set of data principals to ask for a new consent. Now, when you ask for a new consent, you have to send, let us say, an email. This email may actually bounce back also because you may not have a correct email address, which means that the persons whose data you are processing, you have a wrong email address. So the first thing is to eliminate such data principals because you have no right to continue processing that particular data. Second, some of these people may reply back to you saying that I don't want you to continue processing. Now, once you receive that, that also has to be eliminated. However, if people reply positively, or as it may generally happen, they just keep quiet and don't send you any reply, then if you can show me an audit record saying that you have delivered a request for consent, then all those persons' personal data you can continue to process without an issue. But who knows that after 1 week you have started processing, after another 15 days you may get a notice from the same person saying that last month you sent me a request, I was too busy, could not reply. Now I am saying please don't process, which means that you have to send the request for renewal of notice to all your current data principals, then monitor if any of them bounces back, any of them send you a rejection immediately or anytime, and then accordingly prune your list of data principals whom you have to process. So this is another major activity which you need to work on. But if you don't get the response, at least you can continue. And such a notice has to be given in at least 22 languages, which is as per Schedule 8. You have to give it in English with an option for the person to get the same notice in 22 languages. Fortunately, the type of notice is very simple. Earlier, we had a very complicated notice with several points to be covered there. Here, you have to only tell the data principal what is the type personal data which is being collected and why, the purpose. Other than this, you have to only tell him that if you have any grievance, we have a grievance redressal mechanism. If you have got any complaint, this is the Data Protection Board email address. You can send the complaint there. So now notice is very simple. So even if you are thinking of translating it to multiple languages, it should not be a problem. But remember that like in every other law, the onus of proof to show that you have got the consent remains with the company, and therefore you should get the consent and tag it with the personal data. The significant data fiduciaries have three main obligations. One is to appoint a data protection officer who is based in India and who should be senior enough to be considered as responsible directly to the board. And he will also be the point of contact for grievance redressal. Okay, so he is a data principle oriented person, and he should be capable of dealing with persons who may be very unreasonable and they may raise complaints and irritate the data protection officer. So to be a data protection officer, it is very tough. Now you should have that kind of a soft, empathetic approach to deal with the people. Like people say, people like us who are in banks, we know that in the bank, a old depositor is always a pain for most of the people because dealing with them is very tough. But that is what is required for a good DPO. You cannot live in an ivory tower and say, I am the best IT person in India and why should I care? You don't understand what is there in IT. People will say that people will come up with all sorts of complaints. Some of them are very ridiculous, but you cannot put them down. Rather, you should be able to meet their grievances and redress them. So being a data protection officer is a combination of being the best technical mind, the legal mind, and also being able to handle this PR with the data principles. Then the second aspect of a significant data fiduciary is to appoint an independent data auditor who will evaluate the compliance in accordance with the provisions of the Act. Probably he will be an external auditor. Once in a year, he will do this audit. Third is undertaking periodic, what we call as a data protection impact assessment, so that from time to time, you will analyze whether we are in compliance or not. Earlier, the word concurrent audit was used. Now it has not been used, but still I think the concept is similar. Other than these special obligations of the significant data fiduciaries, the general obligations applicable to all data fiduciaries is one, to be compliant with the law in general, have a valid contract if you are outsourcing any data processing, personal data processing. Okay, if it is non-personal data processing, it goes into the Information Technology Act, but personal data processing comes here. And if the data is collected at one point of time, but subsequently used for decision making or disclosure, it has to be updated from time to time. Then you have to implement appropriate technical and organizational measures, which is what we generally call as compliance by design, and then take reasonable safeguards to protect the data, which is the CIA, confidentiality, integrity, and availability of personal data in the organization. And in case, unfortunately, there is any data breach, notify the data breach both to the Data Protection Board and to the data principal within a reasonable time. The time limit will be perhaps given in the subsequent notification. You know, in ITA 2000, within 6 hours, you have to give the data breach notification. So if a data breach happens and it is of even personal data, at least the CERT-in will be waiting for your notification within 6 hours. So here, even if 72 hours something is given, as was in the previous versions, you still have to be ready to report to the CERT-in at a much quicker time frame. Now, other obligations, one has to process it for lawful purpose with consent or for specified legitimate uses. give a notice and take a consent, have a grievance redressal system, give the business contact information of the data protection officer, and where data protection officer is not required, like the non-significant data fiduciaries, at least a compliance officer's details have to be given. And sometimes if a person asks you to withdraw the consent and erase the data, if there is no other compulsions of law, it is an obligation for you to erase. If you have got other obligations, don't delete it. In fact, ITA 2000 has many cases where you have to maintain data for at least 6 months, in some cases for 5 years. And IT Act, that is the Income Tax Act, and others may require your data to be kept for a longer time. So only after taking that into consideration, you have an obligation to erase the data once the purpose for which it was collected is over. And in the case of people with language preferences, you have to give it to them. And there is also a provision called consent manager. Maybe Anirban can speak more about consent manager. At that time, I will perhaps expand on that. And as I told you, withdrawal of consent, when it is there, if it adversely affects the organization, that is data fiduciary, you can ask for some compensation from the data principal. Like in the case of right to information, if you ask for right to information and if it requires printing of voluminous data, the information officer can ask you to pay the cost of the printing. Likewise here also, when the withdrawal of consent takes place, if there is any cost incidence, data fiduciary may say that you have to take care of that particular cost. Then as far as publicly available data is concerned, this act has a very unique feature. It says, if personal data has been made publicly available by a data principal, then such data can be processed and it will not actually come under this act. So it becomes like an anonymized data. You can process it, but you have to ensure that the data is being made publicly available by the individual. If somebody has stolen my data and put it in the public place, that does not constitute public data. Children's data, obviously you should have the consent from the guardians. Whatever is applicable to children is also applicable to other people who are not capable of taking their own decisions, like mentally challenged persons and so on. Now, there are certain cases where legitimate users have been defined, and in such cases, explicit consent is not required. It is not that only government has taken such things. Private sector, in many of its activities, can use data under legitimate use. For example, when a data principal has voluntarily provided the information, or when there is a legal obligation to comply with judgments for medical emergency, and for taking any action during a disaster, flood, or something like that. And even in the case of employment, if you want to process the personal data for the purpose of employment, it is considered as a legitimate use. And also to protect the employer from, say, frauds, corporate espionage, and other things, you can process employees' data. This is another area where this act differs from GDPR. GDPR is restricting the use of employee data very significantly. Here, it is much more industry friendly. As far as the rights are concerned, this act talks of rights along with the duties. It expects that there are 4 kinds of rights. One is the right to access, where a person can ask a company, are you processing my data? If so, tell me what you are doing. Give me a summary kind of a thing. Second is right to correction and erasure, that the data principal can ask the company to correct the data and say that if the purpose is over, please erase it. That erasure happens if the company does not have any other legal compulsion to retain it. Then third right is right of grievance redressal. And fourth right is right to nominate the personal data to my legal heirs perhaps, or any other person who is accountable for the legal error. This is going to be another very important area in terms of compliance, because excepting the bankers and such people who handle the property, the IT companies are not fully aware of how to deal with the deceased data. Now they have to have policies for that, and that is something which will be necessary to work on a separate plane, like you should have claim procedure for personal data, because personal data may be very valuable. It may have IP rights, it may have, say, NFT or Bitcoin data, which may be just there in your email address. So they are very valuable, and it has got a property value, and therefore right to nomination has to be handled very, very responsibly. You cannot simply give away the password to somebody who claims that he is the nominee, because who is the nominee, his identity, etc., will also have to be looked at. This is another new area for industries to explore. Then as far as the duties are concerned, data principals are expected to, first of all, be law-abiding citizens. They have to comply with all applicable laws. If there is a Rohingyas who is in India without any permission, he cannot say that I have got privacy rights. So this law is very clear that this law provides certain rights, and rights are applicable to only responsible citizens who are law-abiding persons. It can be non-citizens also, but there should be law-abiding persons. Then they should not impersonate, they should not suppress any material information, they should not register a false or frivolous grievance. They should be able to furnish information which is verifiably authentic. These are the duties of data principles, which is very important and very innovative. Nowhere else in the world that is being thought of. And in fact, in penalties, if somebody doesn't follow these duties, up to 10,000 rupees, there can be a penalty imposed on the data principal, like the courts which normally impose costs on frivolous public interest litigations. Now, cross-border transfer, at this point of time, the Act does not say any restrictions. We have to wait and see if in future certain countries are notified as blacklisted countries. At this point of time, there is no cross-border restrictions. Penalties are classified into 7 different categories. Maximum penalty under this table is 250 crores, but penalty under one category can be combined with another category, so the total penalty can be higher than 250 crores. There is also a viewpoint which some people have expressed, that if there are data breaches of 100 data principals, maybe this penalty could be multiplied by that 100. We do not know how the Data Protection Board will say interpret that, but anyway, the penalty can be huge, and it is not restricted to 250 crores, not even restricted to 500 crores. Penalties may be invoked by a data principal when he makes a complaint and the Data Protection Board conducts an inquiry, and during the inquiry, if it finds that there is a non-compliance, this penalty can be imposed. When penalty is imposed, the penalty is collected and credited to the Consolidated Fund of India. This 200 crores, 250 crores is not coming to the data principal, because this law is meant to discipline the data fiduciary industry. So therefore, there is a provision that you have to be compliant for the following points. If not, you will be required to pay penalties, and that penalty goes for to the Consolidated Fund of India. If individuals want to get any compensation, probably the Data Protection Board can direct the data fiduciary to pay some compensation. Otherwise, the data principal has to approach the adjudicator under Information Technology Act and then claim the compensation. Now, if Data Protection Board comes to know of an incident outside a complaint, then also they can order an inquiry. And if Data Protection Board wants to conduct an inquiry, it will give opportunity for the data fiduciary to present its case, and then gives out this award. It's not an award, it's a penalty. And if people are not happy with that, they can go for an appeal to TDSAT. And if the decision of TDSAT is not acceptable, they can go to Supreme Court, which means that there is no other civil court. Lawyers may please take note that there is not going to be any case in any civil court as far as data protection law is concerned. It is Data Protection Board, TDSAT, and then Supreme Court. In the ITA 2000, there was a 5 crore limit for adjudication, and above 5 crore it could go to the court. And then After TDSAT as an appeal authority under ITA 2000, the appeal was coming back to High Court and then only going to Supreme Court. Here, this exclusive jurisdiction of the DPB bars any other civil court, irrespective of the amount involved, to take up this violation of Data Protection Act. I have already covered these rights of the data principle. So if you think this is what the act is in brief, then companies need to start working on the compliance by creating an inventory of personal data, segregating the what I call as a DPDPA data from GDPR data, because you cannot apply GDPR on Indian data or Indian law on GDPR data. So you need to have a segregation of data, however difficult is that is for your technology group, you have to get it done. So segregate DPDPA data from GDPR data or CCPA data or Singapore data, estimate the non-employee personal data exposure. That is, employees will be there everywhere. Non-employee personal data depends on the type of activity you are in. Please make an estimate and include it in the inventory. Send consent requests and follow up on these bounced messages, rejection, and keep evidence of the messages sent. Set up policy for rights management, like how do you handle data access and erasure requests, check on nomination requirements, set up a deceased data principle policy and claim settlement policy, develop a legitimate use policy, revise the notice formats if you are using anything, and consent recording process, develop a data retention policy in compliance with this particular law, develop a grievance redressal policy and a setup, identify processes which involve personal data, because you can have different roles in different processes, I said. If considered you are a significant data fiduciary, consider the DPO, DA and DPIA request. This is a bird's eye view of the DPDPA, and I leave it now for Dr. Anirban to continue with his views on what kind of opportunities exist out of this, and subsequently we can take questions and answers Friday and Saturday.